Hi, everyone. Welcome to this special Brennan Center for Justice event. For those of you joining us for the first time, the Brennan Center is a nonpartisan law and policy institute that works to repair, revitalize, and defend our systems of democracy and justice so they work for all Americans. My name is Faiza Patel. I'm the Senior Director of the Liberty and National Security Program at the Brennan Center for Justice. Before we get started, just a few housekeeping notes. First, the Brennan Center is a nonpartisan organization. That means that while we do not support or oppose any candidate for office, we can, and today we will, vigorously debate the policies and positions that matter for our democracy. Second, civility is important to us. Those of you who post rude or intemperate comments in our message streams here in YouTube or Facebook will be removed from the conversation. Live closed captioning will be provided, and you can follow along the conversation on social media with the hashtag Brennan Center Live. And now to today's program. So as all of you no doubt know, yesterday brought a historic victory for the rule of law. A three-judge panel of the D.C. Circuit Court of Appeals rejected Donald Trump's claim that he's immune from criminal prosecution. The former president, who is currently the subject of 4 criminal cases, argued that he can't be held criminally liable for official actions taken during his presidency if he wasn't first impeached and convicted by Congress. The appeal temporarily halted preparations for his federal election interference trial, the outcome of which could move the needle in the 2024 presidential contest, according to recent polling. By flatly rejecting Trump's bid to be shielded from accountability, the appeals court has reaffirmed the core democratic principle: no one is above the law. The decision also brings Trump one step closer to being tried for his sweeping efforts to disrupt the peaceful transfer of power in 2020, which culminated in the January 6th attack on the U.S. Capitol. Here to discuss what might happen next and the ramifications of the ruling for Trump and for American democracy are our panel of experts. They are Michael Waldman, who is the president and CEO of the Brennan Center for Justice; Holly Brewer, who is a professor of history at the University of Maryland; Joyce Vance, also a law professor at the University of Alabama Law School and the former Attorney General for the Northern District of Alabama; and Aziz Huq, professor of law at the University of Chicago Law School. Good afternoon, everyone. Now, let's get started with a few questions, and we'll reserve some time at the end for audience Q&A as well. So, Michael, let's start with you. Can you tell us exactly what Trump was asking the court to do and break down for us why the D.C. Circuit's ruling is so historic?
Thank you, Faiza, and it's great to be with such a great group of experts and colleagues. I think this is a landmark ruling. It is, among other things, the first time that a federal appellate court has said that a president is not immune from criminal prosecution. Now, of course, there has been no other president who has been indicted and faced with criminal prosecution, but it is an open matter in the law, even if it's an easy matter. The ruling is very significant. It's 58 pages. It goes in great detail into looking at and rejecting what Trump was asking for. What Donald Trump was saying was that just as it is widely assumed that sitting presidents cannot be criminally prosecuted, former presidents, Trump said, also cannot be criminally prosecuted for acts while they were in office. In the argument at the court, he with Trump sitting there, his lawyers, put on a good effort and said that the key was that under the Constitution, supposedly, that the president would need to be impeached and convicted for there to be a possibility thereafter of criminal prosecution. At the argument, the question was asked, well, could he order SEAL Team 6 to assassinate an opponent and not be prosecuted unless he's convicted by the Senate, and presumably the Senate cowering under their desks in fear of assassination? And Trump's lawyer said, yes, he could only be convicted, criminally prosecuted, if there'd already been a conviction. It's significant because it's an important step in holding presidents accountable and making it clear that they're not above the law. As the court said deftly, I thought they didn't go into too much of the kind of presidents are not kings argument that we're using in this conversation. They said, as far as this matter is concerned, he's not president. He's a former president. He's Citizen Trump. It's significant if it moves the trial along. The trial date was March 4th. Judge Chutkan postponed the trial date. Court of Appeals took quite a bit longer than people like me thought they might have in actually reaching this ruling. Hopefully, what that means is it is a rock solid, bulletproof ruling that will not require a whole soup to nuts rehearing, re-arguing, and time delay at the Supreme Court.
Thank you, Michael. Aziz, turning to you now, what do you think the consequences would have been politically and legally if the appeals court had sided with Trump? You're mute, Aziz.
As Michael said, there are two pathways the appeals court could have taken in embracing former President Trump's arguments. One would have had extremely sweeping legal consequences. The other one would have had narrow legal consequences, but dramatic political consequences. The broader ruling would have rested upon Trump's assertion that there was an implicit immunity from criminal prosecution for perhaps just the president, perhaps all executive branch officials exercising discretionary authority. His briefs fluctuate between those two positions. That sort of ruling would have essentially disabled much of the federal criminal law that for generations has applied to not just the president, but many other officials. That would have been a dramatic and tectonic change in our legal system. The narrower argument that Trump made, and the one that was, I think, all along the place that he was hoping to prevail, was the idea that the fact of an acquittal during an impeachment proceeding precluded the possibility of a subsequent criminal trial. Now, the Court of Appeals, I think, rightly rejected that argument on a multiplicity of grounds. There are more than one reason for rejecting the legal significance of an acquittal in an impeachment that Trump identified. But had that been the ruling, or had the ruling gone off in Trump's favor on that ground, really the only person who plausibly would have benefited was President Trump. So that would have been a ticket good really for one ride only. I think that ruling would have torpedoed the possibility of further criminal proceedings, whether in the District of Columbia or in the District of Florida, where Special Counsel Jack Smith's other case has been filed. And obviously that would have changed the landscape of the 2024 election.
Joyce, let me just turn to you now. Can you join the conversation and talk to us a little bit about what the court's ruling means for Trump's legal landscape, specifically the trial on federal election interference charges, which was postponed, which is meant to start in March?
Sure. So this was an all or nothing motion for Trump. It was his gambit. If he had succeeded with this motion, then the charges would have been dismissed and there would have been no trial in this case and possibly in all of the other cases, with the exception of the Manhattan District Attorney's prosecution, where the conduct precedes his time in office. So what's the state of play going forward? The January 6th related case, what I typically call the election interference case in front of Judge Chutkan in the District of Columbia, it's amazing to me still that there are so many prosecutions of a former president that we have to go to so much trouble to clarify which one we're talking about. But this is the prosecution brought by Jack Smith, the special prosecutor at DOJ. That case has been on hold while this appeal moves forward. Some people have been concerned about that, but I'm in my background a former appellate chief in my office before I was the U.S. attorney. This sort of a stay while an appeal is underway in this unusual interlocutory posture ahead of trial. It's not unusual to have a stay. In fact, it's very much expected. The question is, when can Judge Chutkan restart her clock and go back to the work of preparing this case for trial? The panel from the Court of Appeals gave us a very strong timeline. Trump has until Monday to file with the Supreme Court for a continued stay, a continued stoppage of proceedings in front of the district court. If he doesn't do that, or if the Supreme Court can't muster 5 votes to give him a stay, then Judge Chutkan will be back in business, and that case will begin to prepare for trial. She had promised Trump at the outset something like 7 months in total of preparation time. I think we'll see this sort of day-to-day equivalence where she will extend her calendar to accommodate the period of time that pretrial proceedings have been on hold while this appeal has been moving. So this is the interesting thing about this appeal process in the Supreme Court. The first stage will just be deciding whether proceedings are stayed in front of the district court. And the Supreme Court usually will enter an administrative stay, at least for long enough to the panel to decide, or rather for the court to decide whether they're going to hear the case. They want to keep everything as it is for that period of time. Then there will be briefing. The court will have to decide whether or not it intends to hear the case itself or let the DC appeals court's decision stand. And look, if the Supreme Court, and there's a possibility it takes 4 votes to hear a case, it's possible that they won't want to hear this case. The appellate court's decision is very straightforward, very comprehensive, and this is quite frankly not a difficult issue. There is no universe in which Donald Trump has immunity for his official acts and we continue to be a democracy. So I suppose there's some possibility that even though it's a momentous case of first impression, that the Supreme Court will let it go. Then Judge Chutkan is back in business and we could have a late summer trial. She herself contemplated that possibility in a hearing earlier this week where she suggested she might have to suspend some summer travel plans because she would be in trial. If the Supreme Court does agree to hear the case, the timeline is very uncertain. They could expedite proceedings like they have with the 14th Amendment cases. They could do it quickly, which in appellate court time might mean 6-8 weeks, and that's very optimistic. Or this could be added to their docket and a decision could be made at the tail end of this term in June or July. Some folks have even suggested that they could take the case and put it off for the following term, although I think that's unlikely. All that to say, lots of uncertainty in the calendar that will be resolved over the next couple of weeks.
Yes, it's definitely something to be watching closely. Holly, can I just bring you in with your historian's perspective? Now, Trump's legal team cited Alexander Hamilton's writing in support of its immunity claim. The court, though, it reached the opposite conclusion. Did it get history right?
Absolutely. In fact, they really were misusing Hamilton. There's no question. Hamilton's Federalist number 69, which is what they were quoting, is an extended digression on the question of why the president is not a king. And he makes a point of saying repeatedly that the president has much more limited powers in terms of veto power or pardoning power, in terms of the length of time that he can be in office, in terms of questions of accountability before the law. So the whole thrust of what Hamilton is saying is about limiting the president's power. And the way that Trump's lawyers were arguing, they were essentially saying that there was a huge limit on the president's accountability, that the only way that a president could be held accountable before a court of justice was if he had first been impeached and then the impeachment was, and then convicted in the Senate, and that that there was meant to, they were parsing some of the language in Hamilton's Federalist paper, essentially arguing that one was dependent on the other. But in fact, that is a really forced reading even of Hamilton. But if you actually go to what's called the impeachment judgment clause in the Constitution, which is what, in fact, the appeals court did, it says judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. And the appeals court rightly emphasized the nevertheless part of that. So meaning regardless of what happens in terms of the impeachment and the trial in the Senate, the president will be accountable to the law. And why this is so important conceptually to understand is that if the president cannot be held accountable for his actions, you are essentially creating a monarch, someone who has no obligation to uphold the law, and cannot be forced to do so in any way, shape, or form. And you're creating someone who has the potential to take over the republic and turn our whole system into something that was very different from that designed by the Constitution. So that I'm going to just tell a quick anecdote. On the last day of the convention, and this is an anecdote that's been quoted in some way, shape, and form before, but I think it bears thinking about the whole of it. On the last day of the convention, Elizabeth Willing Powell, who was prominent in Philadelphia as a socialite, asked Dr. Benjamin Franklin. She said, "Dr. Franklin, she said, well, doctor, what have we got? A republic or a monarchy?" And he answered, "A republic, if you can keep it." And what I pause here to say is what he meant by that was quite literally, it's a monarchy if you cannot, we don't have ways to restrain the president. And that is the crucial difference. And therefore, the impeachment judgment clause is absolutely central to the balance of power under the Constitution and to keeping the republic.
Thank you for that, Holly. Michael, coming back to you and to slightly more recent history, how does the court's decision compare to the Supreme Court's Nixon-era presidential immunity rulings?
Well, this is consistent with all the other major recent rulings by the Supreme Court and other similar courts, in that in the Nixon era was first propounded the idea that presidents who were in office could not be prosecuted. This was actually something of an afterthought. It was in I believe, a footnote of an Office of Legal Counsel memo explaining why the vice president at the time, Spiro Agnew, could be prosecuted. But the U.S. v. Nixon case, which was the significant case that ultimately led to Nixon leaving office, that was not about whether he could be prosecuted, but whether he could be required to produce evidence in a criminal trial. He was an unindicted co-conspirator in that trial, but this was about whether he would have to turn over some of his secret White House tapes to the grand jury and to the trial for evidence. But there have been other cases and other examples along the years where this idea that former presidents could be prosecuted has been deeply baked into the law. When Gerald Ford, Nixon's successor as president, pardoned him, explicitly he said, well, the pardon said this is because he's about to be indicted, and that would be terrible for the country to have him go on trial. And in fact, when Nixon accepted the pardon, he knew that he was acknowledging guilt. My former boss, Bill Clinton, reached a deal to give up his law license so he would not be prosecuted after leaving office for the Monica Lewinsky scandal that led to his impeachment and acquittal by the Senate. When Trump was brought up before the Senate in the second of his impeachments, his own lawyer said, well, you shouldn't do this because he can be criminally prosecuted. And Senator McConnell said, we don't need to convict because even though I think he's done terrible things, don't worry, there's a criminal process. So this is about as well established a principle that has never actually been articulated as there is in American law. The other thing that's pretty significant about the Nixon case is they moved really fast. And this is a lesson for the Supreme Court. They understood that timing mattered, and the outcome and getting the oratory right and getting all the footnotes right sometimes is not nearly as important as the timing. And when I heard Professor Vance say, well, we'll be in good shape, there'll be a late summer trial, I practically fell out of my chair, because the timing here is significant for the public, if nothing else. This was a March 4th trial date. So the Supreme Court has many options, which my colleagues will lay out, I know, of how to act here quickly on what is likely to be as close to a foregone conclusion and even a unanimous conclusion, but not take so much time in doing it that it actually undoes the intended outcome of the result.
So, Michael, you seem quite optimistic that the Supreme Court will reach the right result in this case, that it will follow the path set out by the DC Circuit. But the court, of course, has 6 conservative justices, 3 of whom were appointed by Trump himself. How do you think that weighs into the likelihood of what the court is going to rule?
I mean, I suppose anything is possible, but this is one where, first of all, even this Supreme Court, even this supermajority of very conservative justices who largely move in lockstep and have moved the doctrine and the court to the right in a lot of ways, they have not gone out of their way to bail out Donald Trump. They stayed very far away from his claims in 2020. Also in 2020, they ruled that he had to turn over his taxes to the Manhattan district attorney and other things of that nature. One area that they have been reasonably consistent on holding presidents, or this president at least, to account is this kind of core criminal accountability. So I would be quite surprised if they did not rule strongly to uphold what the District of Columbia circuit just did, which suggests that they ought to do it quickly and without stretching their legs in the process.
Well, clearly timing is a big issue here that everyone is really concerned about. When does the decision come out? And how does it affect things? So Joyce, let's talk a little bit about what might happen. So what happens if the election interference trial is ongoing and Trump wins the presidency? Or alternatively, what happens if he's convicted and he still wins the presidency? How do those things get managed in our system?
So there are so many moving pieces here that it becomes a little bit difficult to sort of look at the decision tree of everything. But let's just jump ahead of everything that's going on right now and assume, for the sake of argument, that there's an ongoing trial at the time of the election, that maybe there's a conviction after Trump wins the presidency, and think about what that would look like. Something that I just want to put aside for folks is this notion people often have that DOJ has a policy against taking steps that close to an election that would somehow force them to stop the trial or to not hold a trial. And that's actually not how that policy works. The policy says, and it's a very loose policy, it's not written, different offices use 30 days, 60 days in advance of an election, but it essentially represents this notion that DOJ shouldn't interfere with the outcome of elections. So you don't take overt investigative steps, for instance, that might tip off an investigation into a candidate a week, 2 weeks, a month before an election takes place. You wouldn't indict someone a couple of weeks out from an election. But if you've got a case like this one that's already been indicted, where trial is in the works, where timing is in the hands of the court, there's nothing that prevents going ahead. And in fact, the Attorney General, Merrick Garland, gave an interview a couple of weeks ago where he said that. He said, we've done our part. We indicted last year. This case is now in the court's hands. Could Trump interfere with the outcome? Not before he's president. He can't just swoop in. It's still the Biden administration. But cases take a while. And after a verdict, there's always an appeal process. And if Donald Trump is running the Justice Department, I think we have to take him at his word. Much of what we've seen, this conversation about wanting a Justice Department that's in step with the White House, that in essence becomes a political arm of the White House rather than maintaining the independence that DOJ so notoriously protects on its criminal work, excuse me, if we were to have a Donald Trump presidency where he was prone to interfere, he could certainly direct the attorney general not to move forward with the case on appeal, for instance, just to concede error and ask for the conviction to be reversed. What role the courts might play in that scenario, I think, is interesting. Whether the courts could take steps to intervene, what would happen to the two state court cases that are still out there where Trump doesn't technically have the ability to terminate them. But it gets very messy, both in the cases, but also in the sense of, are we still a democracy where no one is above the law? Do we still have a pristine criminal justice system? You know, our criminal justice system has flaws. It's very aspirational, but people, I think, have at least a modicum of comfort that prosecutors who are career professionals try to always do the right thing. Would Donald Trump succeed in derailing that confidence? These are the very difficult questions we would face in this scenario.
And of course, there's always the possibility that he pardons himself if a conviction happens before he takes office. So, Holly, is there any legal history on this question of a presidential self-pardon?
I want to laugh even thinking about that as a possibility, and of course not. But there are a few cases of presidents pardoning others after they were impeached, which or arguably, I mean, obviously, both President Clinton and President Trump did that while they were in office after impeachment. It's not clear that it had ever happened before. In fact, the one other case that happened was with Andrew Johnson, and in that case, the pardons were not delivered and then not honored. So I would say the very idea of it goes against the Constitution in principle. In other words, it should be logically impossible because, and there's two clauses that are related. First of all, there's an impeachment provision in the an impeachment exception in pardon power of the president. In other words, the president is able to pardon except in cases of impeachment. So therefore, I think there's a claim to be made that neither Clinton nor Trump should have been able to pardon after once being impeached. But I think more generally, so much of the discussion during the Constitutional Convention was about making sure that in cases of treason or insurrection, that there would be ways to make sure that the president was held accountable. And that's why you have the clauses in there, including the provisions we were just talking about accountability, the impeachment judgment clause in particular, so that it should not. Basically, from everything I read of the original debates and in terms of the ratifying conventions, where everyone was assured that it would be impossible for a president to do this because he would be held accountable, a president pardoning himself for such behavior should be impossible, just going against the most important internal logic of the Constitution itself.
Turning now back to Aziz. Aziz, as you know, this bid for immunity from criminal prosecution is far from the only debate that Trump has ignited about the dangers of overbroad executive power, a topic I know is near and dear to your heart. So can you talk to us a little bit about how this relates to other concerns about Trump's assertion of executive power? For example, his threat to invoke the Insurrection Act on his first day in office if he's elected.
I think that the issue here is whether policies that candidate Trump has proposed for 2025 onward raise a specter of criminality on the part of federal officials that casts a shadow upon the rule of law. I think that there are three buckets of such policies that are troubling from a rule of law perspective. But it's hard to see how, in any of these cases, criminal prosecution would, or the risk of criminal prosecution would meaningfully shape people's behavior, such that taking criminal prosecution off the table maybe changes people's incentives at the edges, but probably doesn't do all that much. So the three buckets are first, candidate Trump has suggested removing a set of civil service protections that would make the federal bureaucracy as a whole much more responsive to his as opposed to statutory law, or his whims as opposed to statutory law. Second, as you say, he's suggested invoking the Insurrection Act, which carves out an exception to the general bar on the use of the military in the United States. People are concerned that that would be invoked to deploy armed forces on the part of the federal government against peaceful protest. I would note that even in Portland in 2020, where no one thought that the Insurrection Act had been invoked, you had hundreds of federal troops on the streets of downtown Portland. Those troops, because they were under DHS rather than within the ambit of the armed forces, were not covered by the Insurrection Act. So even if you set aside the legal questions about the Insurrection Act, there is, regardless, a concern about the way in which the non-military coercive forces of the federal government might be deployed. And then the last bucket I would note is that proposals to aggressively ramp up immigration law enforcement in the homeland in ways that directly impinge upon people's physical well-being or security. Now, across all of these contexts, it's possible to imagine policies that lead to acts that in the ordinary course of things would be criminal. And ordinarily, we think of the criminal law as being a constraint, a shadow. Now, had the Court of Appeals gone the other way, or if the law does, for whatever reason, go the other way at some point, that shadow goes away. Here's the thing. We are now more than 3 years away from January 6, 2021. Whatever happens now, it is very clear that it is extremely hard, even with a friendly Department of Justice, a Department of Justice that is, at least in this regard, committed to the rule of law. It is extremely hard to get these kinds of prosecutions off the ground and get them moving, and that it is relatively easy to run the clock. And given that that fact is already on the table, I would not look to the criminal law as a constraint upon the various forms of illegality that one might see where some of the policies I mentioned pursued.
So just to follow up on that, Aziz, you say you would not look to the criminal law. So what would you look to?
I think if you see some of the policies I described, whether they be the use of troops, the use of the DHS to enforce ordinary law and order or public order norms, or the use of DHS or contractors to enforce the immigration law, we would expect to see lawsuits seeking injunctive relief from being brought relatively quickly. I would anticipate that, in part because, at least in many parts of the country, you have politically variegated, politically varied district court benches and courts of appeal benches, that those initial requests for injunctive relief are going to have some success. I think that there is a likelihood of constraints on the front end through litigation, in other words, as well as public criticism that will probably have some effect. But the chances that an official will think, well, if I violate a constitutional norm or a criminal statute, I might down the road be subject to a damages action or even a criminal prosecution. I think that those are just really unlikely to shape individual officers' decisions. And I would flag that, at least from what we know of the application of criminal statutes to, for example, policing, it's not the prospect of criminal liability that really shapes police behavior. So it's not clear why we should think that that would happen in this quite unusual hypothetical scenario.
Thanks. It's super interesting. I'm wondering if any of the other panelists want to weigh in on this issue, or whether we should go to audience questions, of which we have many, although more are always welcome. So please do send along your questions for our panelists.
I'll just add to the really significant note that Aziz just raised, is if it turns out that the criminal law has significant hindrances on its effectiveness, although why Attorney General Garland waited as long as he did to proceed is chief among them. We already know that the other major accountability mechanism articulated in the Constitution, that is impeachment, has been almost entirely neutered when it comes to presidents. Once it was seen as an extraordinary sanction, so alarming that Nixon resigned rather than face conviction. Now it's been used multiple times. No president has been removed from office. We saw the failed impeachment attempt yesterday against a cabinet secretary, and I think people now realize that it's been defanged in a meaningful way. So that's all the more alarming if the courts are not able to play that role.
Okay, well, we have a lot of audience questions, so I'm going to turn to those now. So one question, which I think is something that a lot of people are wondering, is how does this intersect with the ruling that's expected from the Supreme Court regarding Trump being on the ballot in Colorado? Thoughts? Anyone?
Well, as purely a legal matter, they don't intersect. They're two separate and distinct issues. The case we've been discussing talks about whether or not federal prosecutors can try Trump for the election interference charges. The 14th Amendment question is really a political question about whether or not Donald Trump is eligible to serve in office, perhaps to appear on ballots in the different states. So legally, they don't intersect. I think there's been some speculation, at least among the pundit class, about whether or not Supreme Court justices might view the two in tandem. Do they have the will to take on two cases at once? Might there be some horse trading on which case they take and which case they don't? They've put the Fourth Amendment case on a very expedited schedule, getting the briefing concluded and the case to argument tomorrow morning. Perhaps they have more of a willingness on this issue and might be satisfied with the Court of Appeals decision on the other matter, or at least we can hope.
Yeah, I thought that might be a hopeful thing. Okay.
I wanted to say, I think there is one place they do intersect, because I've heard some people argue that in order for the 14th Amendment to take effect, he would have to be convicted on the insurrection charges. But he can't be convicted on any or related charges unless he can be subject to the law. So there is that one possible point of connection, depending on how they interpret the 14th.
Holly, I would just add that the problem with that argument is that he's not charged with insurrection in the January 6th indictment. He's charged under three statutes, not under indictment.
Right. Yeah.
The one way in which I do see there being a pretty intimate connection between these two cases is that they are both dealing in one way or another with this egregious act against the Constitution that Donald Trump engaged in 2020 and 2021. And as likely as I expressed my view, it is that the Supreme Court sooner or later will find that he can be prosecuted. I think many legal observers believe it is also unlikely that this Supreme Court will throw him off the ballot, will bar him from running for president. As a political matter, they did fast track the 14th Amendment case. That was only a few days after they decided not to fast track the independent counsel's request that they hear this immunity case before the Court of Appeals. They may be wishing they had heard them at the same time, because I think there's a lot of expectation that one way or the other, they will seek to find a way to not have to remove him from the ballot, but also to hold him open to criminal accountability. They are legally very different matters. As I said, the immunity case is novel but easy. The other one is more legally untrod territory.
Mm-hmm.
I might just add, elaborating some of the points, particularly that Joyce and Holly made, that the argument that disqualification requires a procedure that runs through federal court, and in particular that it requires a criminal prosecution for the insurrection offense, which explicitly identifies Section 3 disqualification as one of its consequences, is an argument that the court is capable of running with in tomorrow's hearing, even if Jack Smith decided not to bring an insurrection offense. The Section 3 argument is about what the right vehicle is. It's not about whether that vehicle has been used in this case.
Mm-hmm.
Yeah, I think another question is, which I think has been on many people's minds is, why did it take so long to get this decision? Any thoughts?
Well, as an appellate lawyer, I'll just say the decision really didn't take very long at all. Courts of appeals in the DC Circuit is notorious for this, can take over a year to render a decision. They did give us expectation that they would move quickly by agreeing to the expedited schedule. But I don't see anything really out of order as we read this opinion. Michael has pointed out that it's lengthy. Legally, it's very dense. They took up this jurisdictional issue raised in one of the amicus briefs where the amici had argued that it was improper to take this appeal before there had been a trial. And the court spends about 9.5 pages in their opinion laying out the law in that area. That likely took them several days, thinking about the need to have 3 justices all align in order to produce this unanimous opinion. So not really seeing anything out of the ordinary here in terms of timing. If anything, this was really a strong effort by this panel to produce a remarkably clear, pristine, well thought out opinion. And when I say that, I mean that they really dodged some issues that maybe the Supreme Court would have felt the need to chew on. For instance, in the opening pages, they make it clear that they're not talking about immunity issues for sitting presidents, only for former presidents. And that really narrows the issues for consideration and makes it a lot easier for the Supreme Court, if it's inclined to, and that's a big if, to leave the Court of Appeals decision standing.
But I agree with Joyce, but in terms of that part of the whole procedure, but it was puzzling how long it took to appoint a special counsel and to get going on the whole case, to repeat what Michael was saying earlier. And I also wanted to say that things did happen usually much quicker in the late 18th century, that there would have been an expectation that this would happen in months after the original offense. So within a couple months of when former President Trump engaged in these activities, there would have been an investigation by a grand jury and an indictment and everything else, and then a trial. So it is really puzzling about how long it has taken to. I mean, it's been 3 years.
I would add in absolute agreement. It's not just in the late 18th century, but in the rotary phone era. The Nixon tapes case was argued, and 2 weeks later, U.S. v. Nixon was decided, and within 2 weeks, he had resigned from office as a result of things that were set in motion by the ruling. And Bush v. Gore took about 3 days. So I think these courts, we will know if the appeals court took too long. Right. When we know whether the Supreme Court takes the case and how long they take.
Yeah. And not to put too fine a point on, I'm just going to give a funny example, but in the late 18th century, juries could not leave the room until they had come to a decision. Like they were denied food. So I guess they, pissed in a pot in the corner or whatever, but like literally it gave them a real incentive to come to a decision quickly.
Air conditioning and indoor plumbing have ruined everything.
The historical comparison is absolutely fascinating, Holly. I spent 25 years at the Justice Department, worked on a lot of these political cases. The 18th century view sounds fabulous because in this day and age, with all of the, I mean, there are some very real due process considerations that drive how these investigations are conducted. It's very difficult to put together these cases when prosecutors have to be able to prove state of mind, intent to violate the law in some cases beyond a reasonable doubt. It's not at all unusual for public corruption cases to be in the investigative stage for years, 3, 4, 5 years. As a sitting U.S. attorney, I completed cases that were begun during my Bush predecessor's tenure. And so it might be interesting to discuss from the institutional perspective whether we need to do something that lets the system work more quickly than it does today.
Thank you.
Yeah, I think that's really interesting what all of you have to say. I think there's sort of two strains of questions that I want to put together since we're coming close to time to put out for you guys. So one is, what does this ruling mean for the Georgia and the New York prosecutions, so the state law prosecutions? The second is, and I think this would be helpful for the audience, is just like a little timeline. Like it's a little unpredictable, but like what's going to happen next, I think would be really helpful for the audience to understand a little clearly. So who wants to take those up?
I can say something about the first one, but I imagine Joyce also has views on that. The two state cases involving criminal charges in New York and in Georgia are about different kinds of alleged actions by Trump. The New York case is about actions that were taken during the 2016 campaign. The Georgia case is about the same class of alleged election interference that the DC case before Judge Chutkan is. In the New York case, the argument that there was an immunity in consequence of the fact that Trump became president after the acts in question were committed has always seemed to me vanishingly weak, and almost certainly the real or the thing that would derail that case would be Trump coming back into office and a Justice Department motion to intervene in the criminal case seeking to end any ongoing proceedings therein. The Georgia case, I think, presents a different question in the sense that had the Court of Appeals found that Trump was immune in federal court with respect to a class of criminal offenses, I think that the argument that he was not immune in state court would not have been terribly plausible. However, the fact that he's immune, the fact that he loses on his constitutional arguments for criminal immunity in federal court doesn't necessarily eliminate all of the arguments that he might have in the Georgia court. I can imagine arguments based upon a very complex set of doctrinal rules about when and how federal officials can be hauled up before a state court generally. I can imagine arguments based upon that long and somewhat complex set of case law for an immunity in state court, notwithstanding the DC Circuit ruling yesterday. Which is not to say that they're right, just to say that they might, I can imagine them being made.
You know, I think this is such an interesting point, and I absolutely agree with you that we'll see that coming, if for no other reason than it serves Trump's principal strategy, which is to delay proceedings for as long as possible. There was an earlier effort by some of the defendants to remove the Georgia prosecution from federal court to, or rather from state court to federal court. That happened in the New York case too. And in both cases, the courts rejected those moves. But I think we got a preview of some of the types of arguments that they might try to weave together. I think it's pretty thin. I don't think ultimately those arguments are successful. Again, I think that they feed a strategy of trying to delay these cases for as long as possible.
The one possible twist on timing for the trial is that the ruling in the DC Circuit Court of Appeals said that the stay, in other words, the freeze in the trial that Judge Chutkan put in place, would be lifted if Donald Trump tried to appeal to the full appeals court, en banc consideration, as it's called, but would stay in place if he appealed to the Supreme Court. Then the Supreme Court would decide what to do. One of the possible options the Supreme Court has is, first, they could just reject the appeal, deny cert. Thus, this 58-page opinion, which is so strong, is the opinion. They could take the case but lift the stay, and that would enable the trial to go forward. I keep coming back to the underlying fundamental thing that the country deserves, I would argue, and voters deserve a chance to hear the facts in the case and understand the outcome of the case, and that in and of itself ought to have some influence, I would suggest, on the justices and their timing. The fact that the trial is already on hold, I suppose, in some ways diminishes that.
Holly, did you want to weigh in on any of those?
Not on this. No.
Can I add just one point, Faiza, there, which is that in the ordinary course of things, the legal standard for a stay requires a showing of a substantial likelihood of success on the merits. Now, I understand that that standard is not ordinarily used while cases are pending on appeal, pre-trial, which happens in response to, I know what is one of the other questions, when a defendant claims they have an immunity not just from conviction, but an immunity from being tried in the first place. I understand that courts are weaker in their application of the substantial likelihood standard in these kinds of cases. But I would have thought that one of the implications of the united per curiam opinion issued by the DC Circuit is that it's really hard now to say with a straight face that there is a substantial likelihood that Trump will prevail on the merits with respect to his claim of immunity. Right. And if that's right, that gives some force to, or it ought to give some force to the idea that even if the Supreme Court grants cert, as a matter of the law, they should not grant the stay.
Thank you for that, Aziz. Well, unfortunately, the time has come for us to wrap up this fascinating discussion. Thank you to all our panelists, and thank you to everyone who asked these really incisive questions in the chat. Before we wrap up for today, though, I want to ask our panelists one last question. Are you ready? What's the one thing you want our audience to walk away with this afternoon? So let's start with you, Joyce.
So something that I have viewed as the silver lining of the Trump era is the engagement the public has had with this process. I think something that we all have to do as citizens of this country, if we want to keep the answer that Holly talked about earlier to Ben Franklin's comments, if we want to keep the republic, is for us to understand the importance of the rule of law and of citizen engagement. And to the extent that we're doing that here, I think that's what we need to do, what we need to share with others and encourage them to do as well.
Great. Who wants to go next? Holly, would you like to weigh in?
Sure. What I'd like to emphasize is that the founders didn't agree on everything. And in fact, they had substantial debates on exactly how many powers a president should have vis-a-vis Congress and the courts, for example. But they did agree that they wanted to avoid having a president who became a despot or a tyrant or a permanent ruler. They were very aware not only of examples where kings had ruled despotically in 17th century England, and here I speak specifically about Charles I and James II, but they were also very aware and discussed specifically examples of the failures of republics. So the fall of the Roman Republic and the rise of Julius Caesar. And the failure of England's experiment with a republic during the Commonwealth, and the rise of Oliver Cromwell, who became almost a permanent king. And so they those issues were, those constraints and those concerns were built into the Constitution. And if we don't hold a president accountable, if a president is above the law, it is like has the privileges of a king, which is almost what Trump's lawyers were claiming in the hearing, then we risk undermining the very basis of the republic.
Aziz, did you want to give us some last thoughts?
In public discourse today, you hear from both sides an argument: "Oh, we're no longer in a democracy. It's either it's an oligarchy, or it's autocracy, or it's what the government is doing is totalitarian, or the like." And I want to emphasize, you hear that actually from both the sort of the some parts of the left and some parts of the right. And here's an easy way of thinking about whether we're in a world that is characterized by democratic norms or authoritarian norms. So democracies require institutions. Institutions require law. When you're in a world which is a domain in which the word democracy can plausibly be affixed, people engage in these kind of nitpicky, casuistic arguments about rules, precedents, procedures, and they take them seriously. In a world in which democracy doesn't hold, those kinds of arguments have no weight. They are a sham. Right now, the arguments or the positions that we as a group have been playing through are arguments that everyone is taking seriously. Everyone is working through the law. And that is a sign that we are in a democracy, not an authoritarian regime. And that's how you know the difference.
I have little to add to the eloquent comments of my colleagues. The one thing I would say is that when you look at the examples through history of where republics or democracies have failed, where the forces of authoritarian government or authoritarianism have prevailed, it is very often not the strength of the authoritarians, but the loss of heart and lack of fight on the part of those who should be defending democracy, or who should be defending, at the very least, the rule of law and Republican government. It's ultimately up to those of us of whatever political background who care about our Constitution and about the rule of law and our democracy to militantly stand for these basic first principles. That's the key to making sure that we keep this republic.
Thank you, Michael, and thank you to all our panelists and our great audience. You've really sent us some insightful questions, and I wish we had time to answer them all, but alas, it's the hour. I just want to say that the Brennan Center looks forward to seeing you at future events. If you want to know about our events and the work we do, please be sure to sign up at our events newsletter at brennancenter.org/events. And my name is Faiza Patel. Thank you for coming today, and we'll see you soon.